speak about program schedule and yeah.
Good morning to you all. Welcome to the program once again. I also participated in the other two programs earlier and I'm extremely happy to see some of the young faces, some of them are students, and I'm particularly happy that the people of my tribe are more here. I mean, curricular teachers interested in medicine. So I would. I have an explanation because Pandey Sab already mentioned you that I am mapping for a portion of the classes. What I wanted to say was, I am absolutely incompetent to handle a class on evidence law, what is relevancy, what is fact. I don't believe in that, to be frank with you, because it's a kind of, learning through some particular method, which is already abandoned by many reading law schools, and that may, instill some kind of, sense of insecurity and non-cooperation among the students, because it may have the tendency of making you, idle. But instead, if you study the evidence law in the context of the subject which you teach, perhaps it may become quite relevant and may be useful for you. And maybe interesting also, not only beneficial. And in the process, we are not handling the classes for the LLB students. Your law teachers are going to handle the classes. So naturally, what we should do is we should concentrate at the higher levels. I mean, what the Evidence Act has been doing in this country, and after making these enactments, I will draw your kind attention. It is given to you in the Himmat Sukhdev Wakarwag's decision. Paragraph 21 and 25, I am going to read for your benefit. I mean, despite having this wonderful Evidence Act, and the position is not that improved. I am quoting paragraph 21 from this decision. It has already been given to you in the case. Before we embark on an appreciation of the evidence, some quotes come to mind. The criminal justice system, as we understand it as of today, in our country is beset with major issues, sometimes unrelated to what happens in court, particularly in cases involving more than one accused. False and dishonest first information reports, tardy and misdirected investigations, and witnesses committing perjury with not the slightest calm or equivalent make the decision of even the most diligent and focused of judges particularly galling and difficult. Several other factors inhibit the proper conduct of proceedings in a trial. Again, paragraph 26, it's more damaging, more revealing, I should say. In this pernicious state of affairs, the judge, gravely handicapped, has to apply his knowledge of the law and his assessment of normal human behavior to the facts of the case. Note, please read between the lines, I'm reading it again for your benefit. Don't allow yourselves to be distracted from these statements, In this pernicious state of affairs, the judge, gravely handicapped, has to apply his knowledge of the law and his assessment of normal human behavior to the facts of the case. His sixth sense. Excuse me, sir. Yes, you can repeat that. Which one? Our case is given to you. I am reading paragraph 21 and at present I am reading 26. No. It is given. Bharati, yesterday you have learned that. Case number 33. You are not going to this?
688 to 696.
Don't be teacherly, don't be students. Relevant para, I said to you, para 21 and 26 I am reading, okay. And case number 33, because it was given to me by Bharati only, because I am familiar with this case, I have gotten these observations in my annual survey on criminal procedure too. So, I can read it over even without reading it, you know, I mean, I can recite it. Okay, you are reached the stage. It is not necessary that you should read this right now. What I want in my purpose in drawing your attention is only to point out to you that despite the existence or the presence of Evidence Act, this is the situation obtaining in our country. That is all. I just want, in this pernicious, I think all of you have reached the case. In this pernicious state of affairs, the judge, gravely handicapped, has to apply his knowledge of the law and his assessment of normal human behavior to the facts of the case, his sixth sense based on his vast experience as to what must have happened. Oh my God. And then trust to God and good luck that he strikes home to come to a right conclusion. What a pathetic situation. Shower marriage. The last two are undoubtedly imponderable, but they do come into play in negotiating the judicial minefield. This is an undeniable fact, whether we admit it or not. I don't admit it fully, but it is a fact. So, do you mean to say that the Indian Evidence Act is to the purpose? And it is of 2009 decision. Even in 2009, the Indian Supreme Court is lamenting that if the sixth sense of the judge is necessarily to be applied to take a decision. Well, as teachers, I think you should concentrate on this aspect rather than searching for the meaning of fact, relevancy, or primary evidence, secondary evidence. I don't buy that. I mean, that is the reason why I expressed my disagreement, rather, if you can describe so. Well, I think I have explained my position. And firstly, my incompetence. Secondly, non-adherence to this mode of teaching. And thirdly, because, you are teachers. And as teachers, I think, if you look into the journal sections of the reports, or other journals, comments from the law teachers are very, very less. Let me make that submission. I used to be editor of several journals, and I have not come across with any case comments which were publishing in the journals. That would not be the case in the common law country, because if we get sufficient time, kindly go through the comments. I used to mention it every time in every class about Professor Glanville Williams' searching comment on some decision rendered by the House of Lords. Read the Cambridge Law Review 1986, Cambridge Law Review, page 33, it serves my memory, and wherein he calls the judges' quality as asinine. It shows the asinine quality of the judges. I mean, these ass-like, he is virtually calling the judges asses because they had deviated from the statute law in deciding one decision. A case in R versus Shubri, that is 1987 appeal cases, page 1. I do not forget it because I happen to see the caustic comments made by the professor and the very balanced response to the House of Lords in this R versus Shubri. I can tell you the gist of what they said. Well, it is at this juncture that it has been brought to our notice that there is a comment on Anderton versus Ryan by Professor Glanville Williams. Though the comment is done for lack of moderation, it will be churlish on our part not to acknowledge the benefit we have derived from it. That is the kind of role being played by the academies. I want my countrymen to rise to that. And if it helps, if this effort helps to in achieving this idea, I think I consider my spending time is worth. That is another reason why I wanted to. So then, see, for example, when we teach, evidence law, take the case, dying declaration. The basis of acceptance of dying declaration in England is that the popular belief that at the time of departing from this world, man will have a direct communing with his Creator, and he will not die. That is the popular belief English has got. Can it be shared by in India? In the case law, even the House of Lords was constrained to say that at least when evaluating dying declarations from India, we may have to take it with a pinch of salt, this basis. So in the cultural context, you will have to keep in your mind. Another aspect is that, this situation makes it impossible for us to avoid giving enough role for the judge also, because otherwise, you must have seen, in several cases, how did you come to know this? How did you see this? It was dark. It was, sir, there was moonlight. In many cases, you will find that even the Supreme Court has accepted in moonlit sky, it is possible to see. Is it part of jurisprudence or is it part of prudence? Again, you may have to think about it. Evidence law. Is it part of law? Can we say, straight away say that there is a moonlit sky, it can be admitted that it could be seen, like that position can be taken? And take the case of, say, we conduct identification parade. Under what law? Have you checked up? Please look into. The Supreme Court has definitely come up to that. Under Section 8 it can be brought in. It has become a lottery bag now. Anything which is not admitted, is you always rely on Section 8.
Section 9.
Section 9, you read Vashishtha decision. They refer to Section 8 rather than 9. And may become also relevant, but in Siddharth Vashishtha, Manu Sharma, alias Manu Sharma versus University of Delhi, the Supreme Court has located it in Section 8. Well, that we will have enough time to discuss also. So then another aspect which I would like us teachers you to concentrate was, sir, this is by way of explaining my position. I'm sorry, because you raised it, this, I tell you, Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1999. This enactment envisages that the complaint will be gone into by the magistrate's courts, and if it finds that the case is worth, it will be committed on committal only, the sessions or the special court will assume jurisdiction. Suppose it has not been followed, the Supreme Court used to take the position that retrial. In Retiram versus State of Madhya Pradesh, 2012 decision. I will give you citation when we have the classes. Yes, I think this is not the class. I am introducing the. And in Retiram, the Supreme Court reviewed almost all the decisions to the effect that there should be retrial by saying that if there is no failure of justice occasioned by the procedure adopted by the court in avoiding committal proceedings, there need not be any retrial. And if a retrial is ordered at this juncture, that will work against the interest of the accused and the system of justice. And as teachers, I think we should see, is it dependent on the finding of the Supreme Court that there is no failure of justice, that the statutory provision should be kept abeyance, kept out of the system? Non-compliance with the statutory provisions, should it not invite, a step like retrial? And every time the court can, failure of justice, what do you mean by failure of justice? Depending upon the viewpoint of the judge, he can conclude whether there is failure of justice or no failure of justice. The citizen's right is dependent on his finding. Ultimately, it is on his finding again. But at the theoretical level, I feel absolutely unhappy on this decision. You take the case of speedy trial also in our country. Right to speedy trial came to be accepted as part and parcel of Article 21 in several decisions. I wrote recently a piece in NCC also. Rise and fall of a constitutional right to speedy trial. And what has really happened in this situation, the Vidya-mitra Rao's decision, the court said, oh, there is no need for this having this right. It is very difficult to have a right to speedy trial. And to the extent, mind you, till Rajya Sama was 2 versus state of Bihar, till then the same Supreme Court said that it is part of Article 21. And in Ramchandra Rao, they reviewed everything and said that it need not be. Because if there is no failure of justice, if the speedy trial provisions are to be properly implemented, there is no need for such a right. To have a right and to say that there is no need for right because we will take care of the situation. This is a peculiar situation which a teacher should concentrate for research or for learning also. I would like again that thing to be a subject of discussion for you rather than relevancy of facts or facts situation. And then again, in V.K. Shashigala versus Inspector of Police, I am State of Karnataka represented by Inspector of Police, 2012 decision. 2012, yesterday we located the decision. And can you read, until this Indian Evidence Act came in 1872, our constitution, that it came in the case. And is it possible for the Indian Evidence Act to be operative when there is a constitutional provisions are there? I mean, in the context of the constitution only it has to function. And in Shashigala, the question was whether her demand to get some document based on which she appears to have done something which is in the possession of the court should be released for her. It is unexhibited. It's not an exhibit in the court at all. But she said that I need a copy of this. If I am to give you the reply for your memo, I will love to get a copy of this one. Then the same Supreme Court said that, this is a constitutional right. Again, you may have to say, it is a constitutional right, it is not to be confined into the section 2.7 of the CRPC or some other provision of the Indian Evidence Act. Again, you may have to have a relook in the constitutional context. That also has necessarily to be done by the teacher rather than by any other person, another set of people. So that's the reason why, these are the reasons, why I think, we'll get enough opportunity in the right. These are some of the, I studied this American evidence laws. They say that, fruits of the poisonous tree should not be accepted in evidence. That is not the policy we follow. Though the tree is poisonous, fruits are not poisonous, we can take. So even if some illegal ways, if you procure something that becomes relevant for under the Indian Evidence Act, that has to be admitted. Should we follow that? Again, and look at section 106. And I can cite you cases where the very same judiciary has said that, who says that the judge cannot ask any question which may have the tendency to fill the gaps in the prosecution case. Well, he gets the various sections in the Indian Penal Code gets malleable. And if it becomes malleable, and the hands of the judge, is it not dependent on the justice dependent upon the performance of the judge? Is it a satisfactory situation? What should we do as teachers with reference to the functioning of the judiciary, vis-a-vis the Evidence Act or the appreciation of evidence? I think we will have I have more things to share with you. I think I have enough sufficient time. Now it is only explanatory sessions. So it is already 10:30. We will have enough time. I think we can please continue. These are the reasons why. And so kindly don't expect me to deal with the relevancy, facts, all those things. Kindly please don't grill me with that because I am incompetent. But we'll discuss all.
411. It is against human conduct that a sodomy would be committed at 8 o'clock in the morning. Can anybody raise such a presumption? See, the case was that offense of sodomy,
So only in the day.
evidence was that it was conducted at 8 o'clock in the morning. Now the court, Supreme Court, for the first time during discussing evidence, is raising a presumption. It is unlikely against human conduct that sodomy would be conducted at such an early hour.
Subjective, very.
So this is what I am saying.
Stereotyping
That's what
Yeah.
it was.
particularly the interpretation of sexuality on this
That case is also
Such
good law.
Such howlers. So, but this is, thank you, you have pointed out to a law, legislative law में इतना बड़ा flaw. Lawmakers like Stephen etc. who saw the Evidence Act, one voting legislation legally, and they are so meticulous in making IPC or evidence law etc. and giving illustrations which explain the mind of the lawmakers, drafters of the Evidence Act. Now they are so muddled in their, otherwise character is not relevant in matters of accomplice. Is ipso facto a person who is with the criminals. So he cannot be good character or bad character at all. I feel.
See here, you must understand, this is not a normal crime, this is negligence. So, you see, it is not a crime committed deliberately. Where a crime is committed, see, a crime normally is presumed
All
there
the
is a
same
mens
is
rea.
accomplice.
No,
If
a crime presumes there is mens rea. There is a planning. There is a design to commit crime. In accident, there is no design to commit crime. And this refers to a case of accident. And in accident, there may be two kinds of persons. One who says, goes and admits, yes, accident happened due to this negligence committed by both of us. There were two persons. He is saying accident happened due to the negligence of two of us.
Children 4 में भी joint trial तो होगा, joint trial में ये समझ में आ गया, पर उनका character refer करना,
हाँ, character को refer नहीं, character should not have been referred.
जरूरत ही नहीं
Sir,
है.
I want to add something like this. So, it may be that it may be on the minds of this illustration was made. A person of the highest rank. Because generally, if a person is having such conduct that he behaves negligently, and specifically if a person mentions that this person does not work negligently, he is of highest character, and he knows that for what he is being paid, and he should
Character नहीं लिखना था. A very careful man,
carefully.
a very assiduously careful man, and B a equally careful man. ये लिख सकते थे. High character word is wrongly used.
So I give you one good example for this area. In CAP, pilot and co-pilot in the air crash is the accident. Negligence is the time of accident, and that is a good example for this illustration B. Like pilot is a much experienced man, so that is character is called that is called highest character. And co-pilot is a good character. It's equally technically knowledge, but much lesser amount of experience. The negligence.
This is one of the stages of the
A highly qualified man.
Yes, much more experience also counted.
Careful man, qualified man. That should have been enough. High character
High
man.
word is not required.
That is.
Sir, I have a small submission and a query maybe. Sir, do we need to distinguish between character of a witness and character of an accused person? Because as per section 53 of the Indian Evidence Act, the previous good character of an accused person is relevant in criminal proceedings, sir. Section 53 of the Indian Evidence Act provides that. So I think that section 53 has an impact when we are discussing illustration B to section 114 because 53 mandates that. So, sir, any comment on that?
You see, we're talking of accomplice, and accomplice, when he steps into witness box, he is a witness.
Now he is a witness, sir.
Alright?
Yes,
He is also simultaneously an accused.
sir.
So his character, good character or bad character, is in fact reflected that he being an accused, so character is already tarnished, and is a witness. See, a person who is committing dacoity or murder,
But sir, he is only an accused. We cannot say that his character is
so
tarnished already.
when he comes into witness box and is an accomplice, he admits his own role and also role of other.
Yes, sir.
So he is simultaneously an accused. Rather, he admits himself to have committed the crime.
Sir.
Then only he can be called an accomplice and an approver. If he does not admit to his crime, he is neither an approver nor an accomplice. Then he is merely a witness. So he can't be made and examined as an accomplice witness. So at that, since as an accomplice witness, he is an accused, rather admitting commission of crime, that part of the character is already over, that he participated in it. His previous character may be relevant. His previous character will be relevant. Only to show what kind of person he is. But not character as far as that crime is.
Otherwise, highly qualified person, careful person, equally well careful, equally careful person, equally qualified person. So they are in question of negligence. Homicide, criminal 4A, where they certainly put on their trial, they are accomplices. Testimony of each that may make
Sometimes you
sense.
see these words, the character are so widely defined. Integrity is also part of character. Being careful is also part of character. Being honest is also part of character. Being dishonest is not. Character also is
But it starts your
you see, our normal thinking of character is something different. That way we are thinking it. That what character has to be.
In case of
that in English law, they have some different meaning for character in which they include all these things.
in 1872 there may be some different meaning. Terms are being used in different historical
I
periods.
think normal English meaning of character is what characteristics of a person. It refers to all. You see, you are being a morning walker is also a good character. See, so even in normal parlance, you see, he is a very good man. He takes morning walk regularly. He does yoga regularly. He sleeps at time regularly. So all these things are part of character. Or he drinks regularly. is also part of his character.
But they
That
are,
he drinks
they
and
are good character here is a virtue, not as a characteristic, because they have used highest character and equally good character. Good, they are using it as a virtue, not as a characteristic.
No, I'm not saying that. I'm not talking about this. I'm saying normally character can be linked with anything.
That's right.
And there is some minor legislative guideline also, sir. Section 55, there is an explanation appended to section 55 that explains that in section 52, 53, 54 and 55, the word character includes both reputation and disposition. So,
So disposition is important.
Reputation, highest,
general reputation, yes, sir.
highest
Highest
reputation,
reputation.
equally high reputation. To be taken in the sense of carefulness and qualified.
Reputation is part of character. Disposition is also part of character. In what manner the person acts.
Sir, our the term character, instead of looking into physical interpretation, we should look into it in common parlance. In what common parlance?
Character is not our concept of character.
Yes.
Indian concept of character. We look character in a very narrow way.
No, but again, the illustration doesn't relate to 114B very directly. Why? Who is evidence?
That here character was not required to be
No.
stated.
Specifically, they would have mentioned carefulness.
Carefulness में illustration अच्छा बना नहीं Stephen साहब. Stephen साहब मजा नहीं आया. This that is there. I would have told Stephen साहब ये बना नहीं साहब. आप ये separate कर रहे हैं. This is not of your character. It is not my follow your character. This is not a expectation.
चांद में भी एक छोटा सा धब्बा होता है।
हाँ.
स्टीफन साहब को माफ कर दीजिए।
सर, हो सकता है जब जब वो लोग सर्वे कर रहे हैं और रिसर्च कर रहे हैं, तो वो एक ऐसी ऑर्गेनाइजेशन में गए हैं जहाँ पर उन्होंने लोगों से बातचीत की और उन्हें पता चला कि
Yeah, but they don't make law like this. They are very meticulous. If you see my colleague, you see Stephen, the kind of agent, justice agent का जो article है Australian judge का जो article है 2010 का, his lecture in University of Oxford, that is in your material. Justice agent का article है. Stephen's contribution to making of evidence law. How meticulous he was. Each word, each comma, each full stop. This is not acceptable. That's why I'm saying that. And that's why their laws, whether IPC, whether Contract Act, whether Evidence Act, has remained unamended for such a long time. अगर ऐसे ही बनाया होता, जैसे यहाँ के लॉ बनते हैं, जैसे ये जो सेक्सुअल ऑफेंसेस एक्ट अभी नया बना है, अमेंडमेंट एक्ट, क्रिमिनल लॉ अमेंडमेंट एक्ट, with so many laws, सब इधर ही ले आओ, ऑफेंसेस अगेंस्ट स्टेट में ले आओ, 509 भी यही ले आओ, ये सब यही ले आओ, इसको पिछड़ा कोड बना दो ताकि ये खत्म हो. So this they are difficult to understand. So but we are in a great hurry and we don't want to do the.
When everything is running, we start giving them on their delay in lodging FIR. That there is 2 days delay in lodging, say there is a murder case, and 2 or 3 days delay or 4 days delay in lodging FIR is very damaging. But you will find that in rape case, even delay of 1 month in lodging FIR has been not looked upon by the court as serious. And the court has said that this is due to these tendencies in the Indian women. First, they would try to conceal them. Second, they would not confide in male members. If male member is only at home and there is no female member, and if the girl says, I waited for my mother to come, who had gone on pilgrimage, and she came after a week, and I confided in her that what has happened to me, please see that to me. And delay in lodging FIR in all sexual offence cases, mostly. So this is, you see, conduct presumption arising out of the general conduct of the society in cases of sexual offences, see, which is drawn by the courts, normally drawn. And these kind of presumptions you will find scattered all over all the sexual offence cases. Wherever, see, there is delay in reporting it, you find the courts have explained and given credence to this, I take that yes, this is a good explanation or not good. Now recently you must have read articles and some of the, you see, judges' comments after trial court judges' comments. That this finger test of testing, you see, after rape, which is done in order to see if the person, woman was raped or not, if she was habitual to the intercourse or not. This has been found, and they are written. You see, many comments have come that this test should be abolished. Now, if you do not conduct a test after the offence, whether there has been violation of the, you see, of privacy of the woman, and whether she has been raped or not, and you just believe only the version of the victim, this is going to create a havoc. No medical test and simple one. This would be again, there will be no presumption can be there that you need not do any medical test and simply believe what has been stated by them. If this presumption is raised without, and convictions are done without medical test, then you see no conviction is going to stand. Why? Because there is a presumption that if you withhold the best evidence, then that is fatal to the case. Medical evidence is the best evidence. Similarly, in cases of adultery, which is again a sexual offence, you see, the court considers the opportunities available and the normal human conduct that the parties have been seen roaming here and there. They have been going to hotels and have been seen together by many people. Now it is believed that there was all chances of adultery available to them, and if there is allegation of adultery, then this is to be presumed as correct. The onus would be on the other side to disprove. This one thing must be understood clearly. Section 114B mainly deals with onus. Presumptions, if are drawn by the court, and court is free to draw presumption of facts, the onus shifts on the accused to dispel that. And he will have to prove that there was no such thing. See, this section follows immediately the section of onus of proof. On whom lies the onus of proof? Now this may presume is a discretion given to the courts, that court may presume that this could have happened. There is no such thing as shall presume. And when this discretion is given to the court, that court may presume, and if court presumes, exercise this discretion, that ownership on accused to dispel this presumption, and he will have to prove that no, there is no such. Now, you see, there are recent judgments of Supreme Court and something. If a man and woman are living together as husband and wife for a long time, then it is presumed that they are legally married. Even if no proof is given by wife of legal marriage of Saptapadi, which is, you see, under Hindu law, Saptapadi is a precondition of marriage. And under Special Marriage Act, the registration of marriage and presence of witnesses is a precondition. Then only a marriage is considered solemnized. New marriage act also, marriage is considered solemnized when there is a saptapadi, in presence of the society, not in seclusion. That these are the conditions of legal marriage. Now these conditions are being presumed to have been performed by the court by conduct of parties. If the parties are living as man and woman, husband and wife, then they are presumed to be legally married. And the whole concept of living relationship has been crashed and given a go by, that there can be living relationships in India. They have converted living relationship into marriage. And if the husband or the other side say that no, see, sometimes the wife may also say, no, I am not married. It is not only husband, the one to whom it benefits, he or she would say that no, it is not married. Say some ex or wife, husband or wife, out of the two partners, one wants to walk out. He or she would say, no, there was no marriage, you were just living together. The other side at that time can say no, it was a valid marriage, only on the ground that they were living together for a long time and they want children. So this presumption may presume from natural human conduct is, you see, that old, ancient society is lurking in the mind of them. They cannot free themselves from that old society and they cannot give you that liberty which you want to give to yourself. They are not giving.
Can it be said that persons living in where there are man and woman living in a living relationship, the woman cannot claim or charge a man with an offense of rape because they are presumed to be married. And as far as our law system is concerned, a husband cannot be held as rapist.
See, there are, I think, 2 or 3 Supreme Court judgments that if on promise of marriage you live with someone, then you consume also, and then you don't marry, then okay,
The other decision also would say that it is concerned only the court. Whether it is promise of marriage, that's another offense, whether there is cheating. But
should not be raised.
Transaction itself you have consented to. What was the consideration for that? Promise to marry? or
Sir,
that-
live-in relationship comes into existence only when parties are not ready to give the commitment the marriage demands. Okay, anybody is free to walk out. But they are enjoying all the fruits that married couples have had. So in that case, I want to ask you that if the man goes and commits adultery, can the woman charge that man for that offense? Or for rape, can that man be charged?
You see, if the man denies the marriage and says that no, I am not married to her, we were only living in together.
Sir, legal, this.
Let me, then you will have your chance. See, if the man says that no, we were just living in together with consent of each other, I had not promised to marry, but the woman is insisting that no, that we were living together only because he had promised to marry me. An FIR will be registered of rape, then he will have to prove
Sir, but
that whether he promised to marry her.
To the best of my understanding, sir.
Sorry sir, but this is not a satisfying answer.
Sir.
I'm not satisfied.
I'm telling you, I'm telling you legal position.
Sir, I
No,
tell-
I'm telling you the legal position.
But sir, if the legal system is giving a particular position to the live-in marriage in the society, then after that, how can we again raise a question as to what is the man saying? If the law or if the judgments are proclaiming that today live-in relationships have this status, then there is no question of asking what the man is saying.
See, these things arise in different aspects. You see, if you go and claim maintenance of yourself or maintenance of children, you will claim that I am married. And these are legitimate children of the man. And then the court will consider that, see, you are living for so many years together, you have children, so we presume that they will be married. If the man says that no, I am not married, he will have to rebut this. We are talking of presumption, where normal human conduct, this is what I was explaining, that we are still living in that era, when it was not considered as a normal human conduct that a man and a woman would live together without marriage and have. Our codes are not in that state of mind. So, they have converted living relationships into marriage. And they say that if you are living together for a long time, then we will presume you are married. If you want to believe us to believe that you are not married, you will have to. So that is one aspect. Second aspect of rape. See, the allegations of rape are made where long living relationship is not there. Normally, it is a 6 months, 1 year, living relationship is there, and then man wants to walk out. Here the woman says and goes to you see that he was living with me on the promise of marriage, and I allowed her to live or to have consensual intercourse only because he had promised me to marry. Since he has now failed and is not fulfilling the promise, he has committed rape. Consent was conditioned. And only knows that there are decisions of Supreme Court where an FIR on this ground has been concluded. See, it was
Must keep in mind, human relationship fiction can be for different purposes. Human relationship fiction for the purpose of inheritance, for the purpose of maintenance, and human relationship purposes of fixing liability. And it is for the purposes of fixing liability. It is very different from purposes of maintaining law. It is not a legal marriage in that sense. And therefore, the cases will have to be decided what is the purpose of this fiction which has been introduced. It is not something that law has accorded legal sanction. It is for the purpose of inheritance. If you see living relationships, Supreme Court decisions, they have said for the purpose of maintenance, but not for all purposes. You are thinking that once it is a fiction, it should be for all purposes. And marital exemption also should be available or not. Marital exemption itself is very pernicious. That should have been changed by this recent law. But the members of parliament, who are wonderful people, they know the wisdom. हमारा क्या होगा, वही global school, हमारा क्या होगा? आदमियों के ऊपर अत्याचार हो रहा है, आदमियों का ये तो birthright होना चाहिए. Therefore, this birthright only should remain, all other birthright should go. So, this birthright, marital rape का birthright होना चाहिए. उसमें एज वाले इशू में भी इतना कंट्रोवर्सी हुई. I think I've run into with the chairman of the law commission, Justice Lisa, and he said that what will happen to child marriages are very rampant in this country. If you change sixthly, uniformly, many husbands will have to face rape prosecutions. I said, you are saying this at a time 2011, when it is almost 18 years after Convention on the Rights of the Child being ratified by Government of India, and no commission of the Government of India, after ratifying, where definition of a person below the age of 18 is a child. So the so-called husband is having intercourse with the so-called child. She is a child first, and then wife later on. Wife is a ascribed state. So you are falling, your recommendation is falling out of the convention. You have to be very careful. That is how because I am bothered about many husbands who will be subject to it. You are bothered about, but I am bothered about many children being subjected to rape in the name of marriage. So, whether live-in relationship rapes or child marriage relationship rapes, they are rapes. You have to treat them all alike. So 375, 63 should be amended, I feel. But now it has not been amended. Husband has been doing concession and the concession continues. Below the age of 15 and 15th of 16th. But all others, it has been raised to 18. For all others, commercial intercourse till 18 हो गया है. बाकी सब हाँ commercial भी.
Is it legalized now?
Commercial intercourse is actually
Very commercial. State and business.
for money. For money.
301. Article 301.
Then
I'm sorry.
for money, intercourse. For money is prostitution. It is raised to it. But for husband,
Sir, prostitution is legalized in country? Is it legalized? It's not legalized. It's not banned also, but it is not legalized also.
it was never banned.
No, it is not banned, but it doesn't make any legalized.
Practicing
It's just like
is legal, forcing
just like unauthorized colonies.
Practicing is legal, forcing is illegal. Yeah.
As a livelihood, no one is
That's what I'm saying. Practicing is not illegal, forcing is illegal. Yeah.
That is a thing.
And forcing somebody into prostitution is illegal. Prostitution in itself is not.
Moral Traffic Prohibition Act says you make earning out of the activities of a prostitute, third party earning is an offence. But prostitution per se is not legal. It is illegal.
Yes,
But soliciting for money is crime, I believe. Soliciting for money is illegal.
Soliciting also in near educational institutions, place of worship, etc. Section 7 and 8 will only an offence against the
public place.
Public
Public place.
Public.
Not at otherwise.
Yes, public places.
Yes. Not at, you see, in your home, private place. You can solicit.
Cannot this is public place.
It is soliciting at public place.
So sir, does it mean that when we are talking about this live-in relationship, this court, when the court is presuming all these things, a live-in relationship should be considered as marriage? So, what can be the intention of the court to...
Just a minute, sir.
Judicial cognizance of the fact.
Live-in relationship should be considered as marriage. What you see, live-in relationship has been legalized in India only under domestic violence act.
So my question is, my question is bit different. By this presumption, what can be the intention of the court to, does they want to save this institution of marriage? And
They want to protect the women.
Or protect the woman or their
They want to
obligations.
protect the women and the children.
Not from being destitute.
Not from being destitute, and you see, when parties have lived together for too long, she should not be left to miseries, left to face misery. Only for
If they have stayed for a lesser period of time but they are having the children, then also the decision can go in favor of the child and maintenance.
yes, you see, the maintenance, residents are protected by domestic violence. Even if you are not
There is
having,
no presumption of marriage, then also they are.
see, without presumption of marriage also they are protected under domestic violence act, residence and maintenance. And if there is a long period when you have lived together, the court presumes it to be a marriage.
I think in the context of sexual offences, what we must request Justice King, what is very important is the legislative law and the judicial law having undergone a sea transformation in respect to presumption under 114 capital A. Yes, in matters which says again presumption as to absence of consent in certain prosecution for rape. Now, presumption as to absence of consent. Woman states in her evidence before the court that she did not consent. The court shall presume that she did not consent. Only in respect of non-consent, court shall presume. But in respect of intercourse, whether intercourse took place or not, the prosecution has to prove. That has to be proved by the prosecution. All evidence in respect of intercourse has to be
See, the issue of consent.
now, this has undergone a great change, legislative as well as there was a time, 20 years back, pre-Mathura case, where a woman, prostitutrix, was treated like an accomplice. The testimony was seen, taken with a pinch of salt. And this was the male psyche. I know it because I have passed through that stage when I was conscious 20 years back, 20 years. I used to feel very, why this should be there? Can there not be, as a young teacher of law, can there not be cases where a woman doesn't consent? No, but the male psyche at that time, including the lawmaker psyche, judge's psyche was that women enjoy the act. And then later on they turn around and would like to make it complete. The whole folklore was this. Suddenly the folklore changed. And folklore changed not only in India, folklore changed all over the world. William versus William, 1994, House of Lords decision, woman can withdraw consent even at the last moment. It was the case of marital rape. And there was evidence that he had a go. The woman in initial proceedings, she was a party, she was consenting, she was welcoming. But then he did say no. And then he went ahead. And it was raped by the husband. The law had been amended in 1984. Therefore they could do it in 1994. Now, that kind of thinking has gone with the male psyche all over the world. And now in the male psyche in India also possibly. But at the ground level, you ask a policeman, everyone, when this amendment came, everyone said, this is for fame of the police officer. No police officer will investigate cases. This is very unfortunate. As if you read Mahashweta Devi's law, again come back. Nowadays, it stares you on your face. What is happening? What is happening at the level of folklore, jokes? And the prosecutrix, that is what happened in Mathura case. Policemen, after policemen pulled her inside the police station. And then the Honorable Supreme Court saying in Mathura, she should have shouted, अरे पुलिस स्टेशन में जिंदा रहना है आप मर के निकलना है रात में पुलिस स्टेशन में shouting. She didn't make, therefore she consented. That was the mind. Social, I think. We think Bajna Bhumi, Vidya Bhumi. And so it has undergone a change. आज 114 capital A हम लोग पढ़ रहे हैं, we are studying this presumption. And I don't know where Justice Linga, it will still take some time for the spirit of 114 capital A to sink into the minds of even judiciary. Lawmaker ने बना दिया, बड़े courage दिखाई, very courageous. Male lawmakers, majority of them, have made such. But at the ground level, it is still finding, people are finding it very difficult to change this 114A. Therefore, we now and then give out certain good judgment by Justice Anand. I know Justice Anand some good judgment on rape law, in which only prosecutor's testimony conviction is done. Justice Prasad also. For once, Justice Prasad was right in some area. He was a convicting judge otherwise. But in this area, but Justice Anand's deeply thought of, because Justice Anand, I know I have discussed with him length of time. So I have discussed with him and he said that it felt like some of us. So 114A का presumption. Now, I would like Justice under Section 8, which you are very fond of, Section 8J. This is one form of 8 illustration J. One form of sexual offense evidence that comes. 8J में और prosecuted statement में क्या अंतर है? How imagine 8J को भी नॉन रिलेवेंट बनाया है और 8J 8J you have section. Read 8J, illustration J. Somebody will read.
The question is whether A was ravished. The facts that shortly after the alleged rape, she made a complaint relating to the crime, the circumstances under which, and the terms in which the complaint was made are relevant. The fact that without making a complaint, she said that she had been ravished is not relevant as conduct under this section, though it may be relevant as a dying declaration under section 32 clause 1 or as corroborative evidence under section 156.
Dying declaration को कह रहे हैं यहाँ पे dying declaration she is ravished. तो भूली है unless she becomes जिंदा लाश तो dying declaration नहीं कहना चाहिए.
Dying declaration पर क्या she had. She had got a vision.
No, you add करना चाहिए.
As this case was happened, where she was ravished and thereafter she is no longer. And before dying, she had made this statement.
The ravished, she doesn't make. She then appears as a prosecutory witness.
So section
Prosecution witness 1.
So there is a specific line which mentions circumstances of the transaction which resulted in this.
ये 32 में मैं उसे क्वेश्चन नहीं कर रहा हूँ. मैं इनका उदाहरण में देने की बात कर रहे हैं. वो उसको लिमिट क्यों कर रहे हैं 32 में और 157, 32 में she can, more importantly, she can appear as a prosecution witness 1. Prosecution witness 1 जब appear करेगी तब उसका ये कहना कि consent नहीं थी. The court shall presume that consent. That's what I'm saying. तो यहाँ पे ये लिखने की जरूरत नहीं थी.
Suppose she has to meet the circumstances where perhaps she had.
नहीं to read it.
नहीं, इसमें she has made no complaint. They are making two distinctions. One, she has made a complaint of ravishment. Other, she has made no complaint of ravishment, but only stated that she was ravished before that.
Sir,
नहीं illustration J का क्या purpose है यहाँ पे section 8 में डाल.
sir, I would like to submit something. Section 8 is talking about the relevancies. And to the
Section 8 is talking about relevant conduct.
conduct. Yes, sir.
And conduct means whatever in respect of ravishment, whatever conduct she, but not content. There is a distinction between conduct and content. क्या कहा, that is not important. कि ये कहा, complaint किया, ये conduct.
I believe that section 8 relates to the conduct. It makes the conduct relevant. Then it categorically says that statements are not relevant
They are
under
not conduct.
Ah,
Because they are
but
not
then
conduct.
explanation also says that a statement explaining the conduct. So this illustration is used in that context that if there is a statement explaining the conduct, then it is important. Then that statement
That's
becomes
it.
important.
That's it. And content of what she says is a statement. And that is relevant when she comes to witness box as
Yes.
prosecutor. In respect of which 114A will apply. Prosecutrix, or if she dies, then her die declaration, or 157 corroboration, if she dies. If she doesn't die, ravishment से कोई मरता तो नहीं है, excepting in extreme cases of ravishment like liver. So if she dies, majority of cases she doesn't die. तो उसकी testimony वहाँ आएगी.
So what if she commits suicide? After that, then any particular
Yeah, there are cases and cases. Yes, suicide is becomes under 32.
irrelevance है section 8 से कोई मतलब नहीं. 32 अगर suicide करता है, which should relate to circumstances in which
I think they want to put emphasis on that not ending any general statement is to be considered as a conduct, but a statement which specifically comes under the heading complaint. And complaint, we should read it as 2D in the CRPC. Specific allegation made against a particular person.
That she
Only
that
then
she
that
made a
statement.
complaint. That she was shivering. That she was exhausted, looked exhausted. This is all conduct. That she was calling the name. Name is not important. She was shouting.
She was looking.
This is
her clothes were
all conduct. More element है.
See, I'm sorry, but you are mixing our state with her conduct. She was shivering, she was shouting.
State of
It is
State.
also conduct.
No, it is not a conduct. This is state of her state of body.
State of
That she was
state of body and mind.
She was shouting, she was crying. These are not conduct, these are state of her. Conduct is how she behaved. If after ravishment, she goes and makes a complaint, this is her conduct. If after rape, she doesn't go to make a complaint, but only goes home and tells that I have been ravished and commits suicide. Now, this statement, this second part is, you see, makes that statement that I was ravished.
Committing suicide is also conduct.
Committing suicide is a conduct.
Both the conduct are part.
But this statement is,
हाँ.
this is ravished.
Sir, otherwise the circumstances under which and the terms in which the complaint was made.
Yes, circumstances under which,
Circumstances, what is
कोई
circumstances?
circumstances तो कहाँ रही थी वो कहाँ रही थी ये सब circumstances में आएगा. They are all relevant under section 8. They are relevant.
all these things, you see, all these things can be explained only by examples, not by words. See, what were the circumstances, whether she could not make complaint, say, to the police station, and she made complaint only to passerby.
114A.
Now the fire told passerby to call police. This is also a complaint. It is not only a complaint under this. Say she is in a state where she is not able to walk or move, and somebody is worried, she tells that I have been able to please call police. This is a complaint. This will be admissible.
under section 8. फिर क्या 8 में आएगा फिर क्या विटनेस बॉक्स में आएगा जब वो
So all these things are to be
जब
considered.
वो prosecuting says 114 capital A.
See, Professor Pandey has made much emphasis on 114A, but 114A is a superfluous addition.
I said it takes some time for
This is why, no, not because of rape. See, in all rape, consent is to be proved only by the person who alleges it. In all rape, it is never presumed that there was a consent. So, no law says that the court shall presume that there was a consent in it. And if an accused says that no, there was a consent, the onus is on him because consent is a defense.
Sir, I have a small.
It is not
But the
a
problem will be,
Sir,
And see, look into any case where consent has been alleged, it has been proved by the accused.
sir, but problem will be, as Professor Pandey sir has just said, then the consent can be withdrawn even at the last moment. Suppose she has consented earlier, for which you have a proof, like you may be having a letter or SMS or something. But she may always say that even at the last moment I withdrew my consent, and then there will not be any proof.
See, this is what I say, that no court presumes in any rape case consent per se. Consent is a defense.
I have a query regarding this only, sir. Sir, as per the definition of the rape in section 375, it is for the prosecution to bring the elements, sir, and it is one of the elements. So it is for the prosecution. The court cannot presume per se in the absence of section 114A the prosecution has to prove it that it is, these elements are satisfied, one of which is that it was without the consent. And in the absence of section 114A, the job of the prosecution will become almost very difficult.
Just tell me one thing.
So you are saying it is
No, I'm
superfluous.
not saying this. If a sexual intercourse has taken with consent, there will be no effect. Will a woman who has allowed somebody to have sexual intercourse with consent go and lodge an FIR?
So sir, this was the site before Mathura case, I think.
I'm
sir.
not talking of Mathura. I'm talking of a general asking you a question. You are a woman.
Maybe for blackmailing, sir.
See, all right, for blackmailing, then the first thing she will go and record is that I was raped without consent.
And
She will not say that I consented and now for blackmailing I am getting FIR registered.
she will say it is without consent.
It is
sir.
without consent.
But then section 114A will come to her rescue. Section 114, in my humble opinion, sir, it is not superfluous, sir. It is a very important provision.
I don't know. I see. I am not able to understand. If she says a rape offence is made out when it is without consent.
Right.
If she goes and gets an FIR lodged, it means there was no consent.
But the elements have to be proved. Prosecution has
She is coming with
to
an
prove that the elements are present.
So she will be the first witness.
Yes, sir.
And she will say, I was raped without consent, as any other prosecutor says.
So there is a section
Can she say in the court that I was raped with consent and still rape offence continues?
Sir, only if the prosecutor says that it was without my consent. On what basis court will presume that?
This is what I am saying. This is but natural.
It is natural, sir.
It is but natural that when somebody goes to lodge an FIR of rape, then the first thing he will have to say is that I was raped without consent. This is but natural. Whether you write it in the legislature or no, it is but natural that you will go and make a allegation that I was raped without consent. I was raped. Rape itself means no consent.
Without consent, yeah. So that is consent.
If you simply say I was raped and don't record that it was without my consent, rape means without consent.
Yeah.
So when you simply say I was raped by so and so, it means without consent.
With consent in the deceitful lawful marriage, what we have discussed in the live-in relationship. With consent only there is a rape. She is going to lodge a complaint.
Rape cannot be.
He raped me. Okay, what is the reason is the intention is deceitful lawful marriage.
So that is not
That section, that one count is there, another count 376.
Here he is not denying consent.
Deny,
So
not
this
deny.
section doesn't come into consent.
No, what I am saying that section 493 and the 376 will come two counts
So
on.
we are just talking about 114A. 114A, when you lodge an FIR of rape or a complaint of rape, simply you say I have been raped, that would amount to that it is without consent. And if you say without consent, even then it makes no difference, yes, because you are saying rape, it is without consent. The consent is always inferred as to be.
I do not remember the details of one some NRI meeting was there in Bombay, and after party the lady has gone to the hotel room of that particular person. She stayed there and then she said that I was raped. And the presumption was against that lady. How the hell you reached in the hotel room of that person at 4 o'clock in the night?
You see, it is not presumption. It is circumstances which you are supposed to explain. You see, if a man says that no, I did not rape, she came to my hotel and this was with consent. Now he proved that she came of her own to my room at 2 o'clock in the night. Now now you know under section 106 of Evidence Act,
facts.
Onus lies on the person who is in special knowledge of the facts. Now this woman who walks into somebody's room at 2 o'clock in the night has to prove why did she walk into it. If not for this, then she must explain that I came for this purpose and prove it. That this purpose could not wait till morning, that I had to walk in at 2 o'clock in the night.
So meaning thereby her conduct will be the defense of, will act as a defense for
See,
accused. It's very simple.
See, it is always that the consent, no woman in the rape case says that it was with my consent. No woman. You won't find it. One case, reported case where woman has stated that I had intercourse with consent. No woman. Because that case would never reach any court. It will be, you see, on the very first.
That is precisely what needs to be proved. That is to be proved by evidence. And what is the evidence? And presumption rule says 114A that it would be presumed to be without consent. If she is saying, you will have to say in the court, not merely by lodging an FIR. FIR is early stage when the case begins. FIR may be lodged by her father. FIR may be lodged by her brother. Now she becomes prosecution witness 1 and she says that it was without consent. And 114A says the court shall presume that it was without consent. Now this shall presumption can be rebutted by giving evidence, by the burden is on that side. You give evidence that it was then she had written letters to me, that she had given me gift, that she had done all these things. This is to rebut, shall presume 114A, but it will become very difficult. But then, I think just after, then she will have a right, from the prosecution will have a right to cross-examine him. Then re-examine. Witnesses will come again. Did you go at 2 in the night? Why did you go at 2 in the night?
One more thing, sir. Today I was reading in the newspaper and I was very happy. One girl was missing in London, maybe 14 to 15 years after she was caught in the Scotland. But when the inquiry was put up, the police, whether she roved with a boy or something like that, they kept mum, they did not tell anything. Whereas in our country, the police tells everything except the name of the girls and the boy. So why we cannot have similar, because I was so happy to read that police did not reveal anything except the girl is found in Scotland.
If you are reading newspaper, you must be reading that before any charge sheet or before any challan is filed, everything is known to the newspaper people, which is not even known to the accused or to the witnesses.
In that way, no, sir, judges also know everything.
This is what I am saying.
No, sir, the meaning thereby we are more interested in the others' stories than that is the reason.
See, this is something which we can only explain why we are so interested in damaging the character of someone, taking interest in private affairs. आपने पढ़ा हिंदी में है कि निंदा रस जो है वो सबसे लोकप्रिय है,
सबसे प्रिय है।
And see, you should ask him this question.
श्रृंगार से ज़्यादा।
Why on earth he was interested in a girl from England? It means judicial law say 114B, it started as a rule of prudence, very mild, may presume, that accomplice evidence has in course of time. तो अगर तुमने पहले पेंडेट कह दिया तो खत्म हो गया. Then you have to tell the student there are two competing rules of evidence so far as accomplice evidence is concerned. Competing rules हैं. अभी तुमने नहीं कहा कि मैंडेट है या भारी है या हल्का है. One has evolved through legislative at 133. The other is again legislative. law, 114B. But by judicial lobbying, Giovanni-Savu and other cases, it has crystallized into a rule of law. You cannot say if in a case 114B has not been taken into account. I would say that the case is a bad law. Not illegal, but it's a bad judgment. To some extent it becomes, to that extent it becomes illegal. 133 उसको क्लोज कर दे, बचा दे, but it becomes to that extent illegal. Otherwise, why will a student waste his energy? Why will a lawyer argue on 114? And if you see on accomplice evidence, Abu Salim का case है 2012 का, you see Abu Salim's case in which the facts are, and they have done a very good analysis. State versus Abu Salim 2010, 10 Supreme Court cases 179. And they have said that what is the rationale of approval evidence. Now approval evidence, like time declaration, is an exigency evidence. We know एक तरफ तो 155, 156 impeaching the credit of witness, और दूसरी तरफ totally discredited witness को आप rely कर रहे हो. This is a gross violation of best evidence rule. How can you do it? But वो exigency demands. There is no other evidence. He knows so much and other evidence is not forthcoming, therefore as an exigency we make accomplice evidence usable. Otherwise, reaching the credit of witness is most discredited witness. एक तरफ तो trapped witness को discredited मान रहे हो. You are considering trapped witness as discredited. दूसरी तरफ आप accomplice पक्का joint trial में जो था उसको आप permit कर रहे हो कि तुम approver बन जाओ, we promise you pardon और तुम हमारा काम बना दो. So this is exigency, right? To understand. So when you get carried away with approver 133, it is a mandate. So उसमें bias आपने स्टूल के दिमाग को create कर दिया in respect of a legislative law. Don't do that. That student have is free. तभी तो कॉर्पोरेशन वगैरह उसको सब redundant लगता है. कॉर्पोरेशन की जरूरत क्या है? Accomplice evidence is valid और accomplice evidence की basis पे conviction हो सकता है. कोई वो केस ढूंढो. तो आपने उसको पढ़ाया. You have taught him how. Why does he look for correlation? Why does he look for correlation? Giovanni-Savu में क्या कहा यही? Trust of Giovanni-Savu is that there is not enough accomplice evidence is inherently suspected. So, therefore, because this is a very important debate, most of the time the prosecution, the state will like to rely on accomplices. All witnesses are not forthcoming, whether it is in matters of terrorism, whether it is in matters of offences against other offences against state, and state would like to present only one witness. He is coming in. So this therefore topic requires a special kind of treatment. जैसा women witness पे special kind of treatment था, child witness पे special kind of treatment था, उसी तरह accomplice witness पे special kind of treatment. And because he starts from a disadvantage, he is a suspect. 114B therefore becomes may kind of presumption, becomes crystallizes into a law. तो खाली legislative law ही नहीं है, it is the judicial law. And there is nothing wrong in the judicial law. Why are they doing it? Is it to tell the legislator that you are fools, you know everything? It is based on sound common sense. Otherwise, your basic principle of best evidence, justice can be achieved by best evidence, pure evidence. See, legislature has made an exigency, rule of exigency by permitting the approval evidence, making it legal. But you must keep that point. You see, what I say, evidence law is different from CRPC. CRPC is talking about the evidence law is objective purpose, the aims of evidence law. How are the aims of evidence law different from criminal procedure? How are the aims of evidence law different from substantive aims of evidence law? Justice is to be achieved through best evidence, not hearsay evidence, not approval evidence. So, keep that space for the student to think. अगर तुमने पहले ही मैंडेटेड कह दिया, ये सब कह दिया, 133 है, तो फिर उसको 140 भी हुआ, आप वो कृपा कर रहा है आपके ऊपर पढ़े। अदरवाइज 140 भी कॉर्पोरेशन डिपेंडेंट करता है। उसका दिमाग, तो जब लॉयर बनेगा उसका दिमाग वही ढूंढेगा कि साहब वही केसेस अथॉरिटी, then we throw him out, lose his case. Conviction solely on the compulsory cases ढूंढेगा, मिल जाएंगे। कुछ जजेस भी ऐसे हैं जिनको हमारे जैसे क्रिकेट टीचर्स ने पढ़ाया होगा, जज भी जो that's truly caution. And there you flaw those cases, they are making, giving long direction. Nothing, you go judge or you can do anything. All laid down as a Supreme Court. But are comes to realize that you are damaging the philosophy, underlying philosophy of Rumani Sabu and other cases. Why they are taking this step? Unless we justify it, बड़ा जरूरी है सिर्फ approval evidence, solely on approval evidence, without corroboration, conviction goes on.
So what is the relevancy of character of accomplice? Because in case I just go through this illustration B of 114, it's the illustration is regarding illustration. In this illustration they are talking more about character, that when the character of the two person is same, then the court should accept this particular argument.
I formulate your question a little sharper.
No, so actually I am just asking you, since the illustration speaks about that a person of highest character, and then they are saying B, a person of equally good character. Both of them, they took part in some act, and by act of negligence one death was caused. So then they are saying that explain the common carelessness of A and himself. So meaning thereby, if when we are talking about this accomplice, if when two persons are there, so the character of both the persons must be of the same degree. Is it so? Why they have just mentioned this word character, highest character or equally good character?
Yes. this is not an illustration to accomplish evidence. This is an illustration.
Two illustrations.
कंप्लीट एविडेंस का illustration नहीं है। ये सेकंड बी जो है ये कंप्लीट एविडेंस का है।
One accidental where there is no intention to commit crime. You are cleaning your gun, you accidentally shoot. You don't want to commit crime, but these are accidental. In accidental crime, there is a very likelihood of eyewitnesses because there is no design behind committing crime, and the person doesn't take any step to see that what I am doing should not be seen by others. So these are the crimes which are done, which normally get committed in public, and there is possibility of eyewitnesses. Second crime are committed in fit of rage, where you lose your own control. Somebody has abused you, or called names to you, or scratched some of your past history which you wanted to conceal. You get enraged, and in fit of rage you commit crime. And this, in fit of rage, you also commit crime within the family. In fit of rage, you hit your son, you hit your wife, you hit your brother, and a crime gets done. Here you know the consequences, but you are not in your own control. You know that you are holding a kitchen knife, or a stone or a kulhari, and you just hit somebody. You know that this is going to be fatal. Injuries are going to be serious. But since you are committing crime in fit of rage, you don't make an attempt to conceal it. And eyewitnesses are witnesses if they are present. If within the family, son would see what is happening to mother, mother would see what is happening to son. So this is second. Third crime are those which are done purposely, designedly after making mistake. Professionals which are in most of these crimes, professional crimes, you will find that the effort is that there is no eyes. Effort is that even circumstantial evidence is washed out. And the effort is that the crime should not be detected. See, first two crimes, you will see that you will find most of these crimes get convicted or acquitted. There is evidence on see which. It is only the third crime where real investigation is. In first two kind of crimes, practically investigation is recording of statement of someone, seizing the weapon of offense, and this practically there is no investigation, some sending something to labs, etc. But real investigation challenge is only in third, right, where crimes are committed with the design, with scheme, knowledge that this police is going to investigate what I am going to do, and efforts are made to conceal them. So circumstantial evidence actually is the real evidence in criminal cases, real criminal cases. And if you say that circumstantial evidence is a kind of weak evidence, I think no crime which are done by professionals or the person with design can be convicted. No people, no terrorist crime will be then convicted. Terrorists will not be convicted because they all do crime with a motive that they should not be caught and detected. So it is not that circumstantial evidence is a weak kind. Those who say that circumstantial evidence is a weak kind of evidence do not understand criminal law. Because in circumstantial evidence, actually real evidence is circumstantial evidence, which is to be collected and proved by the police in before courts. Because they are the criminals, real criminals. Others are not professional criminals, are real criminals. Others are persons who are most of the time prepared to suffer, and they don't run away from the police. They make no effort to run away. You see, in fit of rage, road rage you have said, people may run away, but ultimately they are caught, either on the basis of registration number of vehicle, or you see, they are living within the area. They are caught a day or two, and there is a victim who will always identify. So, in all crimes which are done by professionals and by the criminals who are who do it design, the crucial evidence is circumstance. See, as you know, it is age-old saying that every criminal leaves behind a trail. So this trail is circumstantial evidence to be collected, and the law of circumstantial evidence is that the chain of evidence which you prove, chain of circumstances which you prove, should be so complete that it should unmistakably point out to the person who is charged with it. There should be no two conclusions. He may have done, he may not. This should be. If the circumstances unmistakably and conclusively point out only to one thing, yes, Mr. X has committed the crime, then you see there is no doubt that X. So what is said is that the chain of circumstances must be complete. If there is a link missing, see, you must have seen last seen evidence. In most of the cases, last seen evidence is given importance, but last seen evidence in itself is not considered sufficient to convict it. There has to be something more than last seen. But there are circumstances. Say, for example, in a room, two friends are sleeping. On the morning, one is found dead. There is only one person who was left there. Nobody has seen the crime. Now the police has to prove that this crime was committed by whom? Either the person who was with that man, he is a criminal, murdered, or if there is someone else, then who is? See, in 106 of Evidence Act, something in the special knowledge of the person is proved by him. Now he will have to, the person who is alive in that room, will have to explain to the police how this man died, if it is an unnatural death. Natural death will come in autopsy, but unnatural death will also be explained by the autopsy. So he will have to explain how this happened, when there is no third person entry. Now then, police will have to collect evidence, all that, and this will be a very grave circumstance against this man, that he alone was there with this man, in the room, and this man got killed and died as unnatural. Unless he doesn't explain it, then it is to be presumed that he is the killer. He is one. So, Arshi murder case is based on this presumption. See, in that house, 2 murders take place. In a room, the house is, there is no proof of entry of any third person into that house. And you see, there is a complete medical evidence which shows, which so far I have not seen the case before, but medical evidence as has been reported, as the case has been going on and reported in the lab, there was a sexual act going on. At the time when it seems the parents noticed something. One of the doctors has given a that this state in which Hemraj was found was possible only if sexual act was taken. So, when see these circumstances, one, there is no entry of any third person. It is not even possible without the notice of parents. See, the house is locked, bolted from outside. Now your daughter is living up. Your servant is found in the daughter's room, and in the morning, you are the only person who found both of them dead. Now, then you have to explain what happened. This is one of the biggest circumstances. Then there are attending circumstances which come. You see, why, how the police can call? This is a question which is asked by Professor Pandey. If the police has not investigated, has after investigation not challaned it, how the court can challenge? How the court can? See, the court is not bound by the police investigation. Conclusions drawn from the police, not police investigation. It is bound by police investigation because court is not the investigating agency. But the conclusions drawn by the police out of the investigation, the court is not bound to it. The police may draw one inference from a circumstance. The court may say, no, it is not proper inference. The police may, you see, in order to show leniency to one of the accused, may not name him. It happens so many times. And the court may find that this is very important evidence against this person, and the police has not even named this man as accused. If you see, there are columns, column number 2, column number 4 in police challan. And police, if charge sheets finds somebody accused of offence, they place him in column number 2. And then they leave mention name of some persons in column number 4 and write that if court considers these persons are also accused, the court may not. So that leverage is there in the court, and it is final authority to accept a closer report or not is the court. That is why otherwise you see the police will be all in all of him drawing conclusions as to whether somebody should be tried or not, whether somebody should be held guilty or not. If we write that he is not guilty, then court is bound. So can the court be so helpless that if police says no, he is not guilty, court says the court can't do it. So in order to prevent that miscarriage of justice, this power has been given to the court to summon accused at every stage. Even at the stage when police files charge sheet, the court can, after scrutiny of charge sheet, challan, whatever you call it, challan, if finds that some of the persons have not been named as accused person, though they have committed it, right, they can be summoned as accused. And the court can discharge also. If court finds that police has wrongly made somebody accused, and actually he, from the evidence, no offence is committed by him, the court can discharge. So as the power of discharging a person is there at the very initial stage, power of summoning someone as accused is also there at very initial stage itself. Then the court has power to summon an accused at subsequent stage in the section 309 CRPC. If some witness comes in the court and gives a testimony that police has all recorded wrong statement, actually I made this statement and this is how crime happened, and these are the persons who were involved in the crime, the court can, you see, believing on the testimony of that witness, can summon additional and ask them to give them charge sheet on the basis of that evidence. And it is not necessary that before summoning, the court should give an opportunity to the accused to cross-examine that person who has given testimony in the court that Mr. XYZ was also in. Stage of cross-examination comes afterwards, because this very witness will have to depose again when this accused is summoned, and you get opportunity to cross-examine. So, the power of court to summon persons is immense and commensurate with the needs of the justice. That justice should be. Now, circumstantial evidence is the only evidence which is available in most of the crucial cases. And these circumstances, as you have read, what the accused was doing prior to the crime is one of the circumstances. This accused was found lurking around the house and seen somebody lurking around the house one day prior to, or if recce was being conducted, say in CCTV camera, there is, see, nowadays CCTV cameras are there. Telephone call records are there. Technical evidence, lot of technical evidence is there, and you must have noticed that most of the crimes are being cracked these days by this IT evidence. And this is not a direct evidence. It is a circumstantial evidence. Now, if a person is found lurking around the house or conducting recce of the place, yes?
Sir, even this CCTV recording is also no direct evidence?
No. See, CCTV camera recording will only show that you are present here. It won't show that you committed the crime. Unless CCTV camera captures the commission of crime. If it captures the commission of crime, the incident itself, then it is a direct evidence. But if
done the assassination, so on CCTV,
Photographs.
no, not CCTV. They will
Photograph is not proof.
Yes. Photographs of
The last photograph which captured the last
Camera they left.
yes. You see the
The
camera
camera
from
The
the
camera they got it.
The camera was also dead. The camera was
Yes.
fractured.
Camera was
Recovered by
gone.
the
Camera was
investigators, sir.
found on the
They
spot.
left behind the camera. And that camera through that camera they reproduce the whole.
Camera
Last was also captured by him.
Yes, you see, Haridasa, who was the photographer,
He was dead on the
he was dead on the spot. His camera was left on the
So
spot.
somewhere else they were.
Nalini was the garlander,
No sir, Bhanu was
Bhanu was the garlander, and Haridas was the photographer. And it is his photographs proved, you see, very material
There is
evidence.
forensic science
That is
vital
direct
role.
evidence. That is direct evidence. That is not circumstantial.
No, that, you see, photograph is the evidence of what is happening. Yes, direct evidence is considered what is direct evidence. Direct evidence is the person who has seen the crime being committed.
But for the camera, they would not have discovered anything.
Yes.
But for the camera.
So that is why it says every accused leaves behind some trace. So circumstantial evidence is a very vital kind of evidence, and it is used in most of the criminal cases which are committed by professionals and committed by designers. It is not that circumstantial evidence is a secondary kind of evidence or something weak kind of evidence. And you will find most of the criminal cases circumstantial evidence is discussed. No collaboration is required. Only thing required is every circumstance relied upon must be proved conclusively. And the fact must be proved. And the chain must be complete. There should be no missing link. Go further, you see how you will corroborate. There is only circumstantial evidence, where from you will corroborate? Corroboration, there can be no oral evidence in such cases. So chain only should be complete.
But coincidence of events, sir. Just now I asked. Coincidence of events.
Yes, coincidence of events are there. You see, is one a vital trait. That you see, you may not be an accused, but you may be present at the spot, and instead of you are having committed crime, someone else has committed the crime. Since you are also on the spot, you may be wrongly held to be an accused. There is every possibility of that. But you see, it is a situation which arises very rarely. That is why it is said that the entire chain should be complete. Now, mere presence on the spot may point out that you may be involved in the crime. But then the whole chain, your post-crime conduct, your pre-crime conduct, your circumstantial conduct, and then motive behind the crime. Whether you have earlier been involved in a similar crime or not, whether you are a professional criminal or not, all these things are seen. See, if it is a possibility that a person goes and commits theft in a hotel, and then you see simultaneously he is accompanied by a bearer who is also going in the same place and goes to the same place, and he is going for cleaning and other is going for theft. But the bearers, you see, conduct that he continued to remain in the hotel even prior to that. He continued his job. After cleaning that place, he went to other place and did everything. No recovery was made from him. All this will be counted. And the fact that no recovery was made from him would be a very vital circumstance to show that he was not thief. See, these inferences which are drawn under Evidence Act, these are all circumstantial evidence from which you draw inferences. if soon after that stolen property is recovered from X, there are two possibilities. That either he purchased or procured stolen property from someone, or he himself is the thief. These are two things. Now, since he is in possession of the property, the onus will be on him to explain how he got in possession. So these circumstances, you see, nowadays your location, since means of communication is cell phone. Cell phone gives you everything. And if you are, you see, something as which is being made by USA, that every communication, every conversation, every email, every SMS is being taped and by a tick, and an eye is being kept on everything. Then you see all these things can be reproduced. Your conversation can be reproduced. Technology is there. That what you talk and to whom you talk is reproduced. So circumstantial evidence is not something weak evidence. There should be no doubt in the mind of anybody that circumstantial evidence in criminal matters is weak. In fact, most of the criminal matters which are done by professionals are with design. They are except circumstantial evidence, no other evidence is available. And if we believe that this circumstantial evidence is a weak evidence, then no person can be convicted. We will be convicting only those persons who are actually not criminals, who have accidentally done crime or who have done crime under fit of rage and they have no intention to repeat the crime. But we are talking of crime. Actually, criminals are those who have become professionals, and they always take care that their presence is not noticed, their way of committing crime is not noticed, and they are not detected. So they take care that there is no evidence. That is why you will find even, you see, cases where revenge is taken. Revenge crime. It is ensured that every person in the family who is witnessing the crime is killed. Why the whole families are killed? Not because they have to take revenge from whole family. The person wants to take revenge from A, B, C, but he will kill D, E, F, G, everybody. So that no witness is left on the spot. And therefore, you see, then how you will prove crime? Only simple. And if you look into cases of Punjab, there is you see land disputes. I mean, in Punjab there have been lot many crimes committed only on grabbing land disputes, division of land, partition of land, my share has not been given that. Or you see, after death of the brother, the wife of the brother is claiming share, and she has not agreed to that ceremony of Chadar Dalna, and she is claiming right of property. So they kill the whole family. There are many reported crimes. And how you prove this crime if you consider circumstantial evidence? And this is also good circumstance that there was a dispute going on between the parties over the land. This is a good circumstance that before the murder took place there was an altercation. Yes.
So I have a question, civil law, since we are talking criminal law, as you have just quoted one example from Punjab case, if the widow don't agree for Chadar ceremony. Now let's say, for example, in this case, if the brother killed the widow as well as the children, then to whom the property will go ultimately?
See, if it is proved that
If it is proved he has killed for that particular purpose only,
he is not he is divested of the property.
Disqualified.
He is disqualified. He is disqualified. The property and property will go to other names. Class A, class B, class C.
And if nobody is there, then it will go to government.
Yes, then by a sheet. By a sheet it goes to state. No, here is left, by a sheet it goes to state.
Sir, we came to realize that circumstantial evidence is a very strong kind of evidence at times. But sir, I think it will depend on the merit of the prosecutor also, and at times the willingness of the judge also, because you said that it must unmistakably and conclusively lead to one story only. So at times they can, because it's very easy to conclude other inferences also. So I'll put some examples, like Satyendra Dubey murder case. CBI investigated the case, they could not find out the persons who were responsible. Everybody knows, like maybe that because of media trial or because of the media propagation, we came to that conclusion. Then there was similar case where an IOC official was burnt alive on a petrol pump. Similar case was reported from Maharashtra, sir. And there are series of cases where everybody knows what would have been the motive of the persons. Satyendra Dubey had written several letters to the NHAI officials also. Everybody has a belief that he was assassinated in fact. But sir, we could not conclude the case, closure report having filed, no witness.
So you see, unfortunate state of investigation. We must you see, know that in our country the investigation is at a very rudimentary stage in our country. See, what you expect of investigators? You expect investigators to find the truth by scientific evidence, as far as possible by scientific evidence. Now, if you have seen Salem case, most of you must have read Salem case. State of Kerala versus the Salvi case, not Salem. Sylvie versus State of Kerala. Not.
That is Article 20 of the
20.
Constitution.
You see, the Supreme Court has given judgment that no accused can be subjected to any of the scientific tests without his consent. And there are many judgments where Supreme Court has written you can't take blood of a person without his consent, because when you give injection for taking blood, insert needle, it is a violence of his You can't take hair sample. I can you see there is a case of Punjab where a 7-year-old girl was raped and in her fist there was some hair. And the police wanted to conduct DNA of the hair of the accused. And that I will come to that. Now it has been amended.
Non-obtrusive interference.
Now just you can't take. You see the DNA of the hair was different. You can't take something. You can't take this. Now what do you expect of police? Do you think police should then the only thing left with the police is data? Recording confessional statements. And this is what police do. Our courts have harped upon against third degree methods of investigation. Right from 1947, when we gained independence, till date, they have been criticizing police for third degree methods, using danda in investigation, recording confession. Simultaneously, our courts have been blocking scientific investigation by them. Simultaneously. You start from 1957 or 56 Kati Kalu case, where the interpretation of section 20 subsection 3 was right interpretation given by a 5 judges bench, that self-incriminating evidence does not mean that you can't take documents, you can't take this. It only means you cannot compel a person to stand in the witness box and depose against him. Now this, the scope of section 23 and self-incriminating evidence have been enlarged to such an extent that entire scientific investigation has been blocked by it, except for recent amendment, which the court has made, that you can take samples of this sample, that also some samples of blood, spit, etc. of the accused. See, I do not understand this mentality of it. There is a basic distrust which is there in the courts against the investigation. And this basic distrust, although there are n number of circumstances by which this distrust has been created, but because of this distrust, you are not allowing even the honest and sincere persons to investigate. The day is not far off when court may say you can't take call record, you can't take this also infringes privacy. And it is infringing. What privacy is there? I don't know how taking blood sample infringes somebody's privacy. You are not taking blood sample to prove something. You are right to investigate is with the police. How to investigate, only police knows. The courts are not expert in investigation. And courts have miserably failed in even those cases where they supervise investigation. Miserably failed. Tell me one case where court supervised investigation and that has resulted into conviction. Still they keep interfering in the area which doesn't belong, in the name of protecting human rights. And this human rights protection actually has turned out to be criminal protection. Criminal protection. That is why you are not able to collect circumstances. And our police then doesn't bother. They are also not trained. If you have courts, untrained courts, can you find fault with the untrained police?
And many a time the police do not work very sincerely. For the fact that they feel that this whole exercise will go in waste. They do not accept.
See, that is no excuse for anybody. But in frustration, you see these encounters which you find, false encounters. See, many police officers will be there to justify that. And many people in private life, those who speak on forums against police encounter, in their private talk, they will justify it. We have two phases of life. This is very unfortunate that most of our intellectuals live two lives. One, what they hold opinion in private, and other, what they hold opinion in public.
So can you say that with respect to case, the Supreme Court acted to investigate the matter and supervising the each and every the proceedings of the CBI? Can we say that?
See, so the Supreme Court ultimately divested itself of supervision.
This is different thing. What I am saying
But
that supervision concern. What you are saying that
you see, directing investigation, I am not finding fault.
They cannot lead the investigation.
Cannot lead the investigation.
That can supervise the investigation.
Neither supervise nor lead. Only magistrate can supervise.
Exactly.
That also.
Exactly.
That also under CF.
Exactly. Provisions says.
Yes. No High Court, no Supreme Court has right to supervise. Yes. They may claim plenary power, but in fact, this is not at all required to be free. They should entrust this job to the person who will belong. So circumstantial evidence, if collected scientifically, is a very strong evidence. And if you know, when DNA see, DNA test was invented, DNA itself was invented, that there is a DNA, something called DNA. And DNA test was invented to find out what is the DNA. You see, not in India, but in US, you see, they preserve samples for quite long time. They have their, you see, preservation system where they preserve the samples of a person who committed crime and against whom the crime was committed for a long time. After DNA came in vogue, you see, their prosecution there as a test whether we convicted right persons or not. You see, did DNA of all samples which are there, lying with them in their storeroom. And they found that many innocent persons have been convicted. Their DNA of their blood did not match with the blood they have preserved. And many persons were acquitted and sent out of jail only on DNA. There is an effort, you see, I think a law is going to be framed or being framed to have a DNA data bank, which is also being opposed. That you cannot have DNA data bank of the criminals. That amounts to infringement of privacy. So, now if you have DNA data bank and the same person is again involved in a crime and you collect some material from the there. You see, now the techniques have come that even if you touch something, you leave your DNA on that. Up to which this Mr. Talwar has been, you see, harping on. You have not Talwar has been harping on that they should refer to America where there are facilities available of touch DNA. So, see, we are advancing in science, but unfortunately we are not using this science perfectly. So the conviction rates, the follow conviction rate, etc. You can't find fault with the law. Circumstantial evidence, if collected properly, see, will give you conclusive clues who did the crime. Conclusive clues. And with the advancement of science, gradually you will be able to pick up what was said in the room, what transpired in the room. Because in the nature nothing dies. Everything, nature preserves everything. Yes.
So, question. England princes have Indian DNA, which is latest news.
Yes.
How it is understand the DNA process used for criminal trial or conclusive? Maybe mistake is there. Scientific evidence.
I'm sorry, but makes it good. DNA stands. You see, when DNA of one race is transferred to other, then from second to third, third to fourth, fourth to fifth. You see, the origin of that is marked somewhere. That where from this DNA came. Origin will be marked. The whole DNA will not be there. The DNA has a big stand of entire spectrum that see, and in this DNA test you can tell whether this portion came from mother, this came from father, this came from grandfather, this came from parent. And you see, when we talk of DNA of the accused and something left behind by him, then it is total DNA match. It is not a match of one strand. So there, what you are talking is one strand. And for your information, all these If you have seen these breeds, dog breeds, where from they are created? All these dog breeds, which we have, let's say here, Doberman, this, that, how they are created? None of them is natural dog. They are breeds created out of wool. And in their DNA you will find DNA of wolf. Yes, they are created by breeding. See, dog with wolf. Otherwise, your original dogs, which are there, they are not breed dogs. They are street dogs. So that is the dog which is an actual dog. All others are, you see, created. And you can trace their breed. In which country they were created. In which country they were created. Yes, what is the, you see, their origin you can trace by even analyzing them. That is how Charles' origin has been traced.
That is a stem cell.
No, stem cell is something altogether different. Stem cell is, you see, a system where your cells are
Preserving for this.
and then from that cell, regeneration of the more cells is done.
That is, we are
Sir, can you briefly tell about pornography, etc., how they were used and why they have been considered to be against Article 20 of the Constitution?
You see, let me tell you, there are three tests: narco test, pornographic test, and brain mapping test. Now, in your Evidence Act, it is very categorically written that any confession made before a police officer is not admissible. So, whether a police officer does a brain, your narco test, or he records statement by any other test, giving you a serum or giving you anything, it will be a confession before police person which will not be admissible. Now, how narco test is, there is a chemical, yes, and if you administer this in controlled quantity to a person, it is not harmful to that man. Physical harm, it doesn't cause any physical harm. However, this takes his mind out of his control. He can't, like thinking changes, give a sequence to his thought as you can give. Okay, policeman is coming, I will state this. Okay, I have to go to teacher, I will make this excuse. Okay, I have to go to my father, I will make this excuse. So that kind of control is lost. And from that, you can, if that man is administered that uncontrolled quantity and you ask him questions, he will answer your question in the natural way, although not natural sound, natural voice, but what his mind is there in his mind, stored in his mind naturally. He won't be able to shadow his information stored in his mind by his own thought.
Subconscious mind.
This is what I mean. So from his subconscious mind, you will be able to extract information. Now, because he is administered serum, that truth serum which is called, and his statement is recorded by keeping him in the supervision of doctor, making him lie on some table, and questions are asked. It is considered that it is violence to him, and it is infringement of his personal human right. You see, the court considers, and in my opinion, Supreme Court considers that if you have to record confession, you must record a with agenda, not with truth. He may speak truth under agenda. Why you are using serum? So that seems to be the philosophy of the court who said that narco test. Otherwise, narco test gives you vital information. Say, you have caught hold of a person after a bomb blast, thinking that he has planted the bomb. Now you subject him to this narco test immediately. You will come to know whether he is actually involved or not. If he is actually involved, you will be able to extract information. What are his future plans? Whether he has already planted bombs at other places which are going to explode, or he intends to plan who are his accomplices, where they are staying. All this information can be extracted. As in any other confession, if discoveries are made on the basis of confession, that becomes admissible. In this confession also, only that part will be admissible which is in purpose of which discoveries are made. I do not find any logic, any reason behind banning narco tests. And narco tests only somebody should give consent. But this is the law of the land. Now, brain mapping is also a technique by which you put electrodes and other things on a person's brain, and when you ask him to make statement. When he makes statement, you see, our brain works in a very peculiar fashion. It sends signals electronically, and our thinking mind, you see, by which we control our brain, that whatever we call it, by which we tell the brain, no, you have not to give this information. No, you have to twist this information. These kind of signals are sent to the brain, then these signals are captured. And then you are able to tell whether this man is giving you complete information or he is not giving you information. Lie detector test is a blood pressure kind of test. It is presumed that when you are speaking lies, there is fluctuation in your blood pressure. And blood pressure equipments are installed on your body. And you see, you are asked to give statement. And I tell you, it is there are people, expert persons who are expert, they can fail these two tests, brain mapping and lie detector, both.
Photography the lie detector. They have been scientifically proved that they are correct.
No, you see,
American Supreme Court, decisions have said they are scientifically not very correct.
You see,
Therefore, they are unconstitutional.
It is not that every science was something which is not scientifically proved is unconstitutional. I'm sorry. There's no constitution. Our constitution only says that we should have the scientific temper. But our Evidence Act does not say that something which is scientifically not proved is not evidence. See, this confession recorded of an accused in police custody is not admissible in evidence. Not because it is scientifically proved that in police custody everybody speaks lies. You may speak truth. But because in police, see, there is a tendency of the police to solve cases, they extract confession. Then confession becomes the easiest way of solving crimes. You need not have any other evidence. Record confession, put him to trial, and police will prove that this is his confession, so this is admissible. So to prevent this, that police, you see, should not sit at a police station and complete investigation by sitting at police station. But you see, we have gone to extremes.
India, in China, 80% of death penalty cases are based on extractive conviction. 80% cases.
But in India,
Therefore, the UN
चाइना में सर कैपिटल पनिशमेंट के लिए क्या कन्फेशन की जरूरत?
extractive confession, कहते हैं extractive confession. UN committee ने on human rights ये कहा कि extractive confession evidence should not be made admissible. और चाइना ने कहा ये हम नहीं करेंगे. तो बहुत आसान है जल्दी से conviction के लिए और हिंदुस्तान में भी लोग समझते नहीं जल्दी conviction कराओ तरह conviction rate high करो और किसी तरह ये के प्रकार एविडेंस कलेक्ट करो सेक्शन 55 को अबॉलिश करो. सबसे पहले तो वो should abolish section 55. The Sylvie case will become meaningless. If you abolish section 55, Sylvie case will not be there. और सारा पुलिस लॉबी तो यही कह रहा है कि Sylvie case से जगह क्यों करते हो? 55 को abolish कर दो. That is their 1872 wisdom. That is colonial law. Colonial law को कैसे हम abolish करें? तो colonial law है, इसलिए colonial law कैसे abolish किया जाए? So therefore, that is the problem.
The problem lies with our conceiving the. You see, we don't conceive things in proper process. Now, there is a case, reported case, which is taught in school, law students. I don't remember the case, where a person killed his entire family and went to police station. Yes. He killed his entire family, went to police station, told police that I have killed my entire family. This is the Kulagi. Here is the
This is
Kulagi.
what prosecution is saying. He
No,
didn't
no,
say, the prosecution is
All
saying
right,
this.
prosecution is. I am telling you, prosecution is saying that this man killed. Let us say prosecution is saying that a person killed his entire family in he is there. Prosecution says that he came to police station and made a statement, recorded FIR. We recorded FIR on the basis of his statement, and then went to his house, discovered bodies, and found that 5 bodies were there. Arm was also recovered, and the cases. Now, the prosecution case is this. We say that this FIR has to be treated as confession, which is recorded by the police because he came to police. And once he comes to police station, he is presumed to be in police custody. This is one presumption we make, that anybody who comes to police station, then he is in police custody. So anybody who reports to the police, he is in police custody, so his statement should not be believed. So this is one presumption we make. This is not at all the purpose of section 20. Then every complainant, whatever he tells the police, he is telling in police custody and he should not. Whether you see, you can't give two treatment, one to complainant and one to it. Second, then you see, if it is a confession, in persons of confession, you see one question which next arises. Can the police dream that somewhere some bodies are lying and we should record an FIR? How the police will gain knowledge of commission of crime unless it is told to them? Either the policeman on the beat knocks at every home. Is everybody alive in the house? Or there is a system of crime being reported to the police. Every crime has to be reported. Say some crime is reported to the police. Somebody has to report to the crime to the police. Police cannot dream of it. If police cannot dream of the crime, let us assume that he made no confession. But he came to the police to say that these many people in my house are lying dead. Now, if he comes and says these many people are lying in my house dead, without saying I committed them, then he must at least say how he got died. He should say, I was not in the house when somebody came and killed them. I discovered them dead. He should come and report to the police that these many crimes have taken place in my house. Please investigate.
So that is the burden on the prosecution.
I'm sorry that you have to read section 106 of Evidence Act. This is the unfortunate thing, that nobody reads section 106 of Evidence Act.
Lordship's story is being brought before you by the prosecution, and my story is different.
What is your story? You have not come forward with.
I need not disclose my story at all.
This is the difficulty, that in
the adversarial system.
No, I'm not changing adversarial. I'm going by adversarial system.
Okay, you can
Say in 313, your story is not this. You have not confessed. In 313, it is an evidence that you came to police station. You have to explain the circumstances under 313, why you came.
That is what police says.
I'm not saying, as an accused, in 313, when you ask a person,
I went to the police station. If the police,
Now-
if section 25 is to be read, 25 to 6, that is what is a safeguard.
I'm not saying denying in safeguard, but section 313 of CRTC in adversarial system casts a duty on the court to
Now then
ask the accused.
The best thing is start with 313. All accused
No,
who
I'm
are
saying after
identified by
entire
the
evidence,
police.
after entire evidence is over, then he is to be put. He is to be put 313. Entire evidence is over. I'm talking of Agnun again.
Then supposing you
Agnun
let us discuss for the sake of discussion. You lessen the burden of prosecution. You don't let prosecution do anything. And 313 you ask him question and say that you explain.
No, I'm
With
not
all
saying-
your now you have relied on the prosecution. How can you rely on the prosecution story?
No, I'm not
That
relying.
is the thrust of 162.
No, I'm not
Nothing
relying.
said by the police.
I'm saying I am a judge. I'm not relying on prosecution.
Sir, may I have a question from this?
I am saying that this FIR is protected as section 25(3). But the fact that you went to police
You
station
said that Muhammad
is not.
Inayatullah case, that Supreme Court decision where a drum of paint was stolen and it was found in a public place. The court said that he may only know about the drums. That is not enough for guilt determination. He may know about the dead bodies. He may know about Tangi. It may have been a design of some zamira to haul him up, because if the whole family is killed and then this man also is hanged, then we'll have all the lands with us. Therefore, all this is a story that is spoken. Now, how do you answer that? The court precisely is understanding it this way. And that is the purpose of 2526. Unless you remove it, then it will become very easy for the 2526. Then many that will be vitiate the best evidence rule. Best evidence is not coming. Your criminal justice becomes to that extent questioning. These are the safeguards, sir.
I'm not denying safeguard. You see, if you are presuming so many things.
Now, if everything,
You see, you presume.
judge knows,
You make presumption as the judge made that at 8 a.m. nobody can commit sodomy. So you are presuming that every person who kills his family has a land with him to over which some zamindar has an eye. It is not necessary that the man may be having land, he may be having no land. And there may be no one else who want to put him in false
मोहम्मद
case.
इनायतुल्लाह में ये
Yeah, this is what I am saying.
ये public
You
place में
can't
doctor
make
नहीं है.
generalized
He
presumptions.
knows about the terms.
Yeah, I'm not denying, but I am not even advanced, gone ahead of one stage when you are presuming so many things. See, I am saying that I go by what prosecution case.
The prosecution
And I go by the safeguard. I'm not going by what
adversarial system थोड़ी हुआ फिर.
No, I'm not going by prosecution case, I'm going by what your stand is. That his statement made before police on the basis of which FIR was recorded is not admissible. So we don't go by what is recorded in FIR. That now he went to police station. Is a fact.
Prosecution कह रहा था. ये case पे.
I'm telling this is what I'm telling you.
ये सारी story
That if
prosecution
you,
बता.
all right, he did not go to police station. Let us presume he did not go to police station. In his house, by murder.
Adversarial system, the burden is on the prosecution.
You see, in
पहले
the
adversarial
adversarial
purpose ही क्या है?
system, only in the adversarial system, section 106 is there, which tells that something.
नहीं, but उसमें आप एक ही section कैसे पकड़ सकते हैं?
That is very important
106.
section.
अगर
If something is in your special knowledge, only you have to.
Sir, by the way, all the report will be influenced by the prosecution or prosecution statement. Because if the case keep coming
No, I
after
give
the
you-
completion of the prosecution, by the time it could be influenced or even some kind of impression that okay, the prosecution is how come the defense or the accused have the opportunity to disprove?
See, accused is presumed innocent. One thing. Whatever be the prosecution story, the accused is presumed innocent still is accused. One. Because he gets every opportunity to cross-examine every witness, which is produced by prosecution only to disprove the story of the prosecution. The whole purpose of cross-examination is to disprove the story and to throw doubt on the story of the prosecution. I am saying in Arjun Nagesh case, let us not. If a policeman appears and he states that he came to police station and made this confession on the basis of which I recorded, we will say this is not admissible, which what you have recorded, because it is self-incriminatory confession. But he came to police station is not a confession. See, he came to police station at such and such time is not a confession statement. It is not inadmissible under any law. Now he.
ये बताइए जब केस होगा तो ये पता कैसे लगेगा he came to the police station या घसीट के पुलिस वाले उसको पकड़ लाए?
मैं भी तो यही कह रहा हूँ.
हाँ, उसको पुलिस वाले पकड़ लाए जब
मैं भी तो यही कह रहा हूँ.
अग्नो नगेशिया घाट काट रहा था अपने खेत में और उसको पकड़ के ले आए.
मैं भी तो यही कह रहा हूँ भाई. उसको ये क्वेश्चन तो पुट करोगे कि भाई आप पुलिस स्टेशन आए थे तो वो ये बताएगा कि मैं घसीट के लाया गया था. मैं घसीट के लाया गया था. आप कह रहे हो आप उसको ये क्वेश्चन ही नहीं पुट करते.
3 और 106 पूरा कंप्लीट कोड हो गया. यही जैसा अभी I was in national ये टाटा इंस्टीट्यूट ऑफ सोशल साइंसेज में conference the Asian Technological Society. Something very similar and it was very good by very good activists. I thought he was good. Prashant Bhushan said, we don't need such a big presentation. We don't need such a big evidence law. We need one section evidence law. We need one section CRPC. And now I said, what are you talking? All these laws are made so elaborately in order to safeguard the liberty of the citizen. Now otherwise फिर इतना सभी झंझट करने की जरूरत क्या है? फिर पढ़ाने की क्या जरूरत है? एक अच्छा जज हो जाए. We need judges of integrity. ऐसे जजेस कहाँ से लाओ? कितने प्रशांत भूषण लाओगे कहाँ से? सब प्रशांत भूषण होंगे क्या? और एक प्रशांत भूषण भी एक सेक्शन के एविडेंस एक्ट में और एक सेक्शन के सीआरपीसी में कैसे करेगा जस्टिस? बिकॉज यू नीड, एंड दिस हैज ओवर ए पीरियड ऑफ टाइम, इट हैज टेकन 700-800 years in advanced countries like US, like USA, जहाँ ये सिस्टम डेवलप हुए। अगर हम लोग सोचें कि हम लोग वापस जाके एक छोटे 106, 313 के कोड में पूरा ट्रुथ समाहित करने और इतने अच्छे जज होंगे, that is too much. ये जजेस कुछ अच्छे भी हो सकते हैं, I am not saying कोई जजेस, but then what about the liberty? It may be put to abuse. It may be trusting the police or trusting the prosecution so much. The whole essence of adversarial system, you know, adversarial system says there should be competing parties, they must be able to present their cases, and their abilities should be access to justice करो, legal aid दो, सब लोग able हो जाए, ऐसा एक assumption है हमारी सोसाइटी में। जहाँ लोग able नहीं है सब लोग equal, वहाँ वो assumption भी fallacious हो जाता है। But then at least उसको लॉयर करने का, लीगल एड का लॉयर मिलेगा, जो कुछ मिलेगा, चाहे टेररिस्ट हो चाहे कोई हो। Otherwise, if you go by the identification done by executive agency, which acts on its own rules, पुलिस वाले अच्छे पुलिस वाले भी हो सकते हैं, but they might be under pressure, conviction rate बढ़ाओ, crime घटाओ, so they would like to arrest Agnu Nagesia, पकड़ो ले जाओ।
The difficulty is that you are very, praiseworthy of Macaulay and Razak. Where the section suits you. This section I am talking are also framed by Macaulay.
But
and
they have to be seen.
Also, but you are not seeing them. You are not seeing, prepared to see the importance of this section.
106 को
I am saying, see, 106 is, I am only saying that 106 casts a duty on the person who has special knowledge to explain to the court how it is done. Now you are saying you can't put this question, either 106 or 313. You see, no, I am not saying, I am saying that the whole thing, you see, you are taking to a stand that if adversarial system is the best system.
No, I'm not saying that.
And in USA, let me tell you, in USA and Europe, the statement.
Question?
Yes, sir. I have a small submission, sir. In fact, I do not find any conflict or any contradictory opinion in what you are saying, sir. Sir, I'll begin with what Honorable Justice started with. Like FIR, you gave a very good insight that in this case, Agnu Nagesia case, peculiar case, where the first informant himself was a person who confessed his crime. This is a prosecution story, as we know, sir. This is a prosecution story. Now, otherwise also we know that FIR has no evidentiary value except for corroborating or contradicting the informant. This is a well-settled principle, sir. And when it is a confession, then it cannot even be used for that purpose also, because it is a confession. Now, but a very good point that Justice have told us to focus is that in India, in law curriculum also, sir, we are not focusing, and on this study only told us, we were not focusing on burden of proof. And that is how this session included section 101 up to section 110. We had a very elaborate discussion.
The whole burden is ignored.
So, and in this case, sir, Agnu Nagesia case actually, as you have said, sir, Agnu Nagesia, they were not his own family members. Agnu Nagesia was actually the nephew of the lady and other relatives. So the murders were not committed in his house, he was living in the neighborhood. So, but in a particular case where the occupier of the house himself comes to the court, police station, and thereby lodges an informant, all my family members are dead, then in that case I really find a point that in the court the judge must ask, section 106 must be invoked, and he must be asked as to, because this fact is in his knowledge, so he must be asked about that facts. But in Agnu Nagesia, the facts are bit different.
See, I am talking, even in Agnu Nagesia,
Sir.
it is Agnu Nagesia who went to police station. Let us forget that he lodged in that. Let us forget that he was, you see, the police fact is right or wrong. But his fact of going to police station is not an admission, and it is not something which is not admissible, inadmissible in law. See, if a police person comes to court and says that Amnu Nagesha came to police station and made a statement, which I record. That part of policeman's statement, that he made a statement, confessional statement, which I recorded. You may say that this confession will not be read in evidence against Amnu Nagesha. But a statement of a witness, whether he is from police or he is from common man, that he came to police station and made a statement to the police, is a fact which you cannot ignore under any circumstance, because the same law which we are reading, CRPC Evidence Act, does not make any distinction between a police witness or a common man. A witness is a witness. You may say that a police person has tendency to speak lies, but same is true with common man. Any person can have tendency to speak lies. Therefore, that can be tested in cross-examination, whether he is speaking lie or he is speaking truth. But the fact that his statement is there that Amnu Nagesha came to police station to make a report is an admissible piece of evidence. It cannot be inadmissible piece of evidence. His confession is inadmissible. So you may not rely on his confession, but you cannot say that this part of testimony that Amnu Nagesha came to police station for lodging some statement is also inadmissible. Now Amnu Nagesha came to police station is a fact which you have to put to him and tribunal, and he will explain to you why did he go to police station if not for lodging report. You will have to put him. You will have to put him.
The trial court should have asked.
This is what I am saying. That this too much adherence to these rules without understanding them is where injustice is being. And this is the whole thing, that we don't understand the importance of rule. Even in this 25, 24 days, you must have seen that where confession statement is made, that I killed X with a knife and only knife is recovered, then only this part that I had a knife is admissible, and whether he killed with the knife is not admissible. If we are dissecting a confession statement to this extent, why in Amnu Nagesha we did not dissect that part of the act, that he went to police station and lodged a report, whether false, wrong or confessional is something different. Now he went to police station of his own is a fact which is recorded by which is proved by the police, by evidence. Now in cross-examination, if he says that no, I did not go to police station of my own, I was dragged there from my field, or some landlord had an eye on my land and there I was to be falsely implicated, he took me, the case would have been altogether different. But when he admits in his P1 also, he does not deny that he did not go to police station for lodging report. Let us forget what is his confession. Now then next piece of evidence is discovery of bodies, discovery of the weapon of offense. Can you ignore all this circumstantial evidence only because you are saying there is confession statement which we cannot read, so we will not read anything else? This is what has happened in Amnu Nagesha. Have you see this happened? What happened in the courts? It is not one case where Amnu Nagesha has done. There are innumerable cases where the High Court or the Supreme Court, while hearing appeal, they find that okay, he has killed his entire family. Now he is left with no family member. He has already suffered a lot. He is in jail for 5 years, because now I see when that Amnu Nagesha happened, the appeal used to be decided in short time. I am not saying he has been in jail for 20 years, which is now the case. So he has already suffered. Why should he be sent to jail? Or why should he be See, these kind of thoughts are there, which you find actually in judgments. You see, you read corruption cases under Prevention of Corruption Act, Supreme Court cases. There is a reported case where a man, his corruption is proved, a police official, he is bribery, taking bribery is proved, and the Supreme Court lets him off by a small fine and undergone few days undergone. On what ground? See, he lost his job because of this. As if a corrupt man should always have his job. And losing job is a punishment. A corrupt man should not lose job. So that is one. He has been facing trial for such a long time. See, now if you see the reasons why trials are faced for a long time, 90% it is the accused who prolongs. 90%. Normally all cases, if you go to Delhi court, you will find that normal case decision making process takes place 2 to 3 years. But where accused wants to prolong, it is 20 years. So he has faced such a long trial. And how they count trial? They will count the appeal period in High Court, the appeal period in Supreme Court, and the trial period. So in every case where High Court delays or Supreme Court delays, the benefit should go to the accused. So it is very, and there, see, it is a practice that when you see a big file, you keep it aside and decide easier cases. And at the end of 10 years, you say, see, now he has already suffered for 10 years, he has been coming to court and going from the court, so he has suffered.
Sir, may I take you away from this case and ask a very basic question which many people may not appreciate in a nice manner, but I am eager to ask the question. Is like recent one accident has happened in the Bombay, one heroine just killed herself. So if two people are in love and after certain period of time one of them goes back and they do not want to continue and the other person goes in depression and then commits suicide, what offense the first person has done?
Nothing.
No offense has been done.
There is case law.
I do not know, sir. That's why I told that this is a very basic question.
You see, this abetment to suicide, committing suicide, abetment means, the law of abetment says, it is very clear that you have to first be in contact with the person who is committing suicide so that he may commit suicide. You have to encourage him that he should commit suicide. Instigate him. That why you are tolerating, say somebody tells somebody, so much insult, if I had been there, I would have committed suicide. This is an instigation. This is an abetment. See, in most of the cases where daughter-in-laws commit suicide, you will find these kind of allegations there. She told me, you see, you are so ugly, if I had been there, I would have committed suicide. Or this, that, why don't you commit suicide? We would be happy, I will marry my son somewhere else if you commit suicide.
It was accepted in instigation.
These are instigation. But if somebody commits suicide in depression, or somebody commits that another person has not acted according to wishes,
The instigation will also depend upon acts, conduct, like what was said, what was done, what letters were written. Instigation.
Can you please elaborate about Deepika case offense? What the Kanda has done? What offenses Kanda must have done?
you see that in order to discuss individual cases, you need to know the entire. See, I can discuss you one case where the one Inspector Namchanda of Delhi Police committed suicide. He was on a case, investigating some case. He was transferred from that case by the Commissioner of Police. And he wrote a suicide note, big suicide note, that during pressure, the investigation of this case, pressure was being put on me, this and that. When I did not come to pressure, the police commissioner transferred me from this case, and therefore I am committing suicide, and police commissioner is responsible for the commission of my crime. He wrote it. There was another case which came to me where a person has written letter before committing suicide that I am committing suicide because of this and this act of Prime Minister. And you may find in South committing suicide for in favor of their leaders and etc. is very much common.
We are lost in the match. Committing suicide.
See, some leader somebody is not elected, say tomorrow some election and Karnataka is not elected as Chief Minister or Amma is not elected as Chief Minister. You will find people, their devotees committing suicide. And somebody writes a letter that I am committing suicide because Karnataka contested against suicide. Then this becomes a good ground for
lump sum amount was there.
So these are not instigations. And in fact, I had given judgment on in that Machanda case, giving what amounts to instigation and how
Intentional abetment or instigation, aid or instigation, intentional.
So it is there that you must intend that this man should commit suicide. And for that, you instigate him.
That is different.
That is not a
Self. Burning others.
Murder.
Third party burning is not included.
See, it is not instigation.
Sir, actually the circumstantial evidences, what is said in the two persons sleeping in a room. One of the police officer came to the university and said something about the investigation process. He said they are practicing the complainant process. Who is making the complaint? They will start with the investigation from the complainant. This is the practice they are using in the circumstantial evidences. Usually they are practicing. Because they don't know about the facts of the crime, who has committed that. That is why they wanted to start with the investigate with the complainant. Then find the facts. There may be a complainant itself a criminal. That is the offender. So that is why they wanted to start with this, the complainant onwards. This is the happening in the investigation process.
See, everybody has his own sort of investigation, but complainant is a source of information.
That is, they wanted to start like this.
Because they want to see from you go to police station for making a complaint.
They suspicious. You don't know.
No, not suspicious, even otherwise. Then the police effort would be to extract as much information from you as possible. So there is nothing objectionable in that.
That is why the people are afraid of
And
going
sometimes, and it quite may happen that sometimes the accused himself, in order to conceal his that I am not the criminal, may go to police and lodge a complaint. And this happens. This happens in many cases. And this is happening nowadays much more. That people feel their own kidnapping for extracting money from father. They feel their own see this, and you see then they become complainants.
I think there is no question from your side. You have been discussing very overarching session on many issues which discussed and clarified your doubts, because this is very important for the course that the teachers themselves must be clear about many doubts. And these small doubts remain, they linger on. say for instance, as you said rightly, parliament is totally ignored. EU parliament was never touched upon, except in section 101, 102, very cursory language. Now 101, 102, 106 also, 105. So all this has come in our discussion. So this is very good.
And you see, in practice, law is applied altogether in different.
And then
It depends on personal whims and fancies of the. See, it is
perception and the lawyer's perception.
See, sometimes even vital evidence.
And this is how you bad judgments are there, bad justice.
And you will not even know what vital evidence has been ignored because it is not even mentioned. See, I know of this case which I decided as a trial court, Ratna trial case. I had convicted him of harboring criminals, harboring terrorists. Now the evidence which was there was that he was Minister of Energy Minister and National Thermal Power Corporation was under him. When this Dawood Ibrahim man went to him and asked for shelter, he asked them to stay in NTPC guest. Now the evidence of their going to NTPC guest him and going to NTPC guest house is there because guest house record is. Now in guest house they stayed for about 4 or 5 days or a week. Since police was behind that, they left the guest house without paying the bills of the guest house. Because, and normally in these guest houses, see there is a contractor who runs the canteen and he charges bill for whatever food is served, and sometimes guest house itself is given to on contract that he will manage the guest house, run the canteen and charge this much government official money and balance will be paid to him. Official charges are always less. Now these people went away without paying bill. Now the contractor started writing to the minister. You see, this bill for these persons have not been paid, who will pay the bill? He wrote to minister's PA. PA replied him that please wait, I will receive instruction from the minister and then give to reply to you. Now this entire correspondence is there. Thereafter he wrote, he wrote that you please treat them as a state guest. So those criminals were treated as state guests and money for their stay was paid out of the state treasury. Now this whole evidence was discussed by me in order to convict Mr. Kalpana Rai for harboring the criminals. This whole evidence is missing from the Supreme Court. And you see, they discuss something else.
But all the same, you are going to totally finish this career. Yes, politician. Otherwise, a very powerful politician. And that is what sometimes surprises you. How did, I am asking this question which is in my mind, how did this Om Prakash Chautala and 53 people, how did their case come to Delhi court? And how did Delhi court convict them?
See, these cases are transferred at the instances of prosecution. And the transfer applications are made. Even in this Kalpana Rai case, he was not made accused.
But in economic offense, 10 years imprisonment, how is it possible? They have been given 7 years to 10 years.
It is there provided.
And they have a right to appeal. They are not given the right to appeal.
No, right to appeal is, right to bail is something different.
Bail
You are talking right to bail.
Right to bail.
Right to bail is there under 389 JRPC as a mandatory right before the trial court if you are sentenced 3 years or below. So wherever the trial court feels that this man should not go to jail, he will sentence him below 3 years. And wherever trial court feels he is a crook of first class, I will see that he goes
that
to
this
jail.
criminal justice system is so powerful that the whole political career and the whole political sort of.
Of course, but normally, you see, this is done by only in exceptional cases. I had gone to recently to Rajasthan Police Academy. Here in Rajasthan, they had analyzed all cases for the sake of section 389. That in serious offences, how many judges are giving sentence beyond 3 years, so that people go to jail. Because I found that in 95% of the cases, judges give sentence below 3 years.
Only
Three are
that
below 3 years.
Jharkhand Chief Minister
So that
Shibu Soren got more than 3 years.
see, in murder case, nobody can give less than 3 years. 3 years. It is to be life or life or death. In murder case, it has to be life or death. Jharkhand Shibu Soren was a
Murder case.
Economic
Murder
offense,
case.
10 years.
In economic offences, you see, it's Prevention of Corruption Act, where disproportionate asset case is there covered, the sentence is up to 10 years. Up to 10 years. And in Kalpana Thai case, I was telling that police has not made Kalpana Thai as an accused. CBI has not made Kalpana Thai as an accused. When I went through the Challan cooperating charges against other accused persons, I found that he is one of the biggest culprits who is harboring the terrorists. And he has not been made accused. And I summoned him on the 3 year. Not 390. At the time of trading charges, I summoned him. As now, Kalwar has been summoned. And then, see, that evidence was there. And what was his reaction? You will be surprised to know. Who is this judge person? Okay, I did surprised. So, the investigators, as they say, they are not afraid of judges. They should have the judge there. Yeah, it's have their information inside stories. None of these politicians are afraid. Only those who are not in power. Once you are not in power, then the story is. Once you are in power, the story is. Yes. So they are all in league. As far as law is concerned, judicial reform, no judicial reform can take place in India. This making legislation, making one amendment in IPC or CRP is not judicial reform. Actual judicial reform lies in making courts, real courts, where decision take place in a reasonable time. Not in 2 weeks. Investigation is over in reasonable time.
That case is taking so much time, fast track court,
See, when we start capsuling the courts, that we will have fast track court for rape cases, we will have fast track court for this cases, and we have not trained our judges that what actually criminal trial means. You can't have fast track court. See why the whole the court system is clogged by 138 cases. Where 138 case should not take more than 3 hearings.
It was a summary trial.
It is a summary trial. It cannot take more than 3 hearings.
There are as many as 8 to 10 law firms which are doing only 138 cases. Bloody cases. Lot of practice 138 firms in the states.
The punishment is enhanced recently. That is 1 year to 2 years.
Not prejudice commission after that.
Thank you very much. This judge, and then in the next you have that Madam Santosh Deiman, another very young judge who has a lot of experience in the courtroom. She was given as a